number 114562 in the matter of the care and treatment of Donald E. Ramage.
Thank you. Before I begin, I'd like to reserve 3 minutes of rebuttal time, if I may.
3 minutes is granted.
3 minutes, okay. This case began, Mr. Ramage was convicted in Sedgwick County in 1988 of, I believe, 5 counts of aggravated indecent liberties. He was sentenced to the Department of Corrections. He was paroled in 2000, and a care and treatment sexual violent predator commitment case was filed under 5929 AO3. However, in December 2000, that matter was dismissed by the Sedgwick County District Court because the petition had not been commenced within the appropriate time. The trial was not going to commence within the appropriate time limits. So the case was dismissed in December. Mr. Ramage was released from custody and placed on parole. And it's important to note he was convicted under the pre-guidelines law at the time. He was paroled in early 2001, and soon after his parole was violated, he was then returned to the custody of the Secretary of Corrections, where he served until 2012. Upon his release in 2012, a second petition was then filed, and counsel at that time filed numerous objections to the filing of the petition. And these were overruled. Mr. Ramage was eventually found to be a sexually violent predator by a jury in Sedgwick County in 2014. This appeal follows. The issue here really is one of more or less an evidentiary issue. The issue regards the law of the case and a related doctrine, res judicata, which can be summarized under the main heading, issue preclusion and admissibility of evidence. The trial counsel filed a number of motions. The one at issue here was a motion to limit testimony. Mr. Sievert, who was trial counsel, argued that the law of the case should preclude the state from using any evidence that had been prepared for the trial in the year 2000, excluding, of course, the statutory requirement of the baseline conviction. He argued that the dismissal operated as a way to preclude that evidence from being introduced.
Mr. Catfield?
Yes, ma'am.
None of that evidence ever got introduced, though, did it? Because the whole thing was dismissed before any evidence was ever admitted.
Well, it was admitted at a probable cause hearing, and that kind of leads into where I'm going, is this dismissal in 2000, is that a dismissal on the merits, which would then mean that you can invoke res judicata or the law of the case doctrines or collateral estoppel, which I don't believe we're arguing here.
Before you go there, can I just explore that theory? Because I'm just having a little bit of trouble even understanding the basic premise of that it would preclude the use of evidence that was used in 2000.
Yes.
Typically what the law of the case does is set something in place. And it seems to me like what you're trying to do is use the law of the case to set something aside. Help me really understand the theory of here.
And again, this is not it's kind of an arcane argument in theory, but the issue is the evidence introduced prior to in the 2000 hearing should not be admitted because the case was dismissed. Therefore, that evidence is not relevant. It is not admissible.
How does law of the case do that, though?
Well, that's kind of the heart of the argument. First of all, you have to have a decision on the merits. Now, the state will obviously argue that there wasn't a decision.
Let's just assume you can establish the elements of law of the case.
Okay.
How does the law of the case keep evidence from being admitted?
Well,
because what law was established? What is the rule of law that you were applying from the first proceeding?
The rule would be that you have a new, all of that was rendered moot by the dismissal. The evidence would not be allowed in. The state has started over, essentially. They're trying to start over. And the statute says that you have to use evidence of his mental condition or mental abnormality. The 2000 dismissal pretty much settled that. It said, no, he's not a sexually violent predator, so that keeps it out. The
Except
state
that
can still...
was- that conclusion was never drawn. That issue was never litigated.
Well, it was a dismissal on the merits. We're arguing it was a dismissal on the merits. That would keep it out.
So dismissal on jurisdictional grounds. At the time, we had a hard and fast rule about the 60-day time limit.
Yeah.
It got dismissed for lack of jurisdiction. Didn't
And-
get dismissed on the merits.
Well, and normally, and I realize that 6241 would say, well, no, it's not a dismissal. A dismissal for jurisdiction is not a dismissal on the merits, but
Right.
there is a case out there, Moore versus Luther, which is 29 Can App 1004, that I came across, and I think was cited in the original motion, that basically holds that it is. Moore was a probate case. There was a tort action, and unfortunately it was filed after the respondent died of unrelated causes. And so what the Kansas Court of Appeals did is it upheld the dismissal, said it was a dismissal on the merits, that you couldn't refile. And so it's inexact, but if you use more, to analogize here, there was no cause of action because you couldn't sue the defendant in Moore because he was dead. I mean, he was physically, for legal purposes, not available. And I think here the same thing is true, that with, in this case, once that dismissal is in effect, actually once the time limit is reached, then Mr. Ramage is no longer legally available. He's a non-entity. And so therefore, it is under Moore versus Luther a judgment on the merits. There's no one to sue. The probate case is effectively closed once you hit that time limit. Now, of course, 5929A03 was later amended in large, no small part because of cases like this. But at the time, it operated under, if you look at Moore versus Luther, it operated as in that opinion, effectively as a judgment on the merits, dismissal on the merits. So, so then what happens is the other thing is that if you look at other cases, there are two cases that have been cited by both sides here. That's In re Johnson, which is a care and treatment case. It's from 2001, and then In re Sporn, which is another case that this court decided in 2009. I think Sporn is probably the more applicable case because the principle that laid out is that there should not be successive. The Sexually Violent Predator Act should not set out successive prosecutions based on the same facts. And if you look at the petitions file, and based on the same facts, I think that's the key phrase here. If you look at the petitions filed in the year 2000 and the petitions filed in 2012, they're virtually identical. And the testimony presented at the 2014 trial relied heavily upon documents prepared prior to 2000. Some were prepared in the 1990s, nearly 20 years before. And those documents, we argue, are hearsay. They were also not relevant because they may have been relevant to Mr. Ramage's condition in the 90s, but they would not necessarily be relevant to his condition in 2014.
How is that true when almost every expert talked about how pedophilia is a lifelong diagnosis?
Well, it is a lifelong, it may be a diagnosis, but the degree is what's at issue here. If you look at Sporn, and also if you look at this other case that Sporn cited, the Turner case, it's out of California, that mental state is not fixed throughout our lifetimes. That I'm not the same person I was 20 years ago, thank goodness. And none of us here are. And that mental state is subject to change. But what the state did in this case is it went way back and relied upon assessments prepared in the 1990s, some of them of dubious value. I'm referring to Dr. Rosenberg's evaluation, which I think is particularly suspect. He was, if the brief goes into detail, the motions do that. Dr. Rosenberg was president of a motorcycle club, had this strange website which dealt with demonic possession as a cause of mental health issues, and that, whether that may not have been admissible even at the 2000 trial, but the fact is that they were relying upon way outdated testimony and evidence. You could argue that, I would say that there may have been enough after 2000, after the first petition was filed, after his return to DOC, to find that he was. We're not saying that this should all go away and Mr. Ramah should be released. What we're saying is that if there's a retrial, they ought to limit the evidence. That's what the original motion was, to limit the testimony. The state may be able to find enough since the second commitment to DOC to prove he's a sexually violent predator. It may not. But what they're doing is simply using that testimony from the first commitment hearing to sort of bolster their case, and they're tacking on maybe a few other things. But the heart of their case is still the evidence that was marshaled for the first petition.
And so let me break that down a little bit just to make sure I understand. You don't have an objection to the second filing?
Well, the filing itself, that would be res judicata, and I think the Johnson case probably addressed that. The Johnson case is a little more on point. Kind of the same procedural status as that Johnson was, found not to be a predator, then he was paroled, came back, and then they filed a second petition. The Court of Appeal said that's fine. I suppose if you follow Johnson, the state would be able to file a second petition. It's what they use to litigate that petition that I think really is at issue here. And it's you have to kind of separate out what they assemble for the first petition and what they would need for the second petition. Does that kind of, because I want to make sure you're clear on this.
Well, I think I'm clear on that.
Yeah.
I'm still not following how rule of the law applies as opposed to perhaps another preclusive doctrine. But it seemed, and you mentioned early in one of your first statements in the argument that you were relying on collateral estoppel, but I did not see that in the briefing.
No, I'm not relying on collateral estoppel, and that wasn't in the motions that the trial counsel filed. But it's a related doctrine.
It is a related doctrine.
But it's not here. Basically, res judicata, collateral estoppel, and the law of the case are all deal with issue preclusion and what you can bring in and what you can't. The law of the case is res judicata is pretty much mandatory. So if you meet the four requirements, you can't file the second case, you can't bring the evidence. And law of the case is a little more directive. It's not mandatory, but it is still something that ought to be given great weight by a trial court.
And what's our standard of review in determining whether or not the court should or shouldn't apply law of the case?
Well, it's a question of law, and therefore you've got unlimited review.
But the previous statement, you made it sound as if it's discretionary. Why is an abuse of discretion doesn't apply? It may be a rule of law as to whether or not the doctrine applies, but as you said, it's not a hard and fast. You have to do it, and there are many exceptions. And so, how do we factor that in?
Well, it may be discretionary, but again, if you look at the case law on it, Supreme Court case back from 1922 says, you have to give great weight to this. You can't, a judge may reconsider the decision, but you should really think long and hard before doing it. And especially also in this case, if you have a different judge seeking to change the decision of the first judge, then I think you have to be very sure about what you're doing. It's discretionary, but I think it's a higher level of discretion than simply a trial level matter.
Any further questions?
If that is all, ladies and gentlemen, thank you very much for your time.
Council, we try to give council time to wrap up when we eat up a lot of their presentation time with our questions. So that courtesy is being extended to you. Do you need 30 seconds to wrap up? Or
I
think you've made your points.
I think I've made my points. If you don't think I have, please feel free to ask me. If not, I believe I can cover it in the rebuttal.
Very well.
Thank you, Your Honor.
May it please the Court, Assistant Solicitor General Dwight Creswell appearing on behalf of the state. The Court of Appeals correctly rejected Ramage's law of the case claims for two reasons. First of all, the law of the case doctrine only applies within the context of a single proceeding. And here, the 2000 and 2012 cases were separate proceedings. Second, the law of the case doctrine has nothing to do with what evidence can be admitted or relied on by the experts, except to the extent there was a prior legal determination on those matters, which there wasn't here. On the first point, the fact that the law of the case doctrine only applies within the context of the same proceeding distinguishes it from collateral estoppel and res judicata. As this court noted in State v. Collier, collateral estoppel prevents relitigation of issues between proceedings, whereas law of the case doctrine applies within a single proceeding. This isn't a situation like State v. Perry, where the state dismissed charges and then immediately refiled them based on the same facts, just to get around an issue that it had already lost. Here, if Ramage had never violated the terms of his parole and been sent back to prison, the state likely would have never brought the 2012 proceeding. The 2012 proceeding was not a subterfuge to get around law of the case. There's also not in Perry that incentive for the state to continually dismiss and refile charges until it wins on the merits. In addition, unlike Perry, these two cases didn't involve the same facts. In 2012, before Ramage's second release from prison, he was evaluated at that time, and that evaluation, which was attached to the petition here, indicated that he's likely a sexually violent predator, in part based on information that postdated the 2012 commitment proceeding. So there are new facts. And the issue in any SVP, sexually violent predator proceeding, is whether the person is currently a sexually violent predator. So in 2012, the question wasn't whether back in 2000 he was a sexually violent predator, it was whether at that time. So you just can't consider these to be the same proceeding.
What evidence did you utilize to make your current finding in 2012? I mean, wasn't there information from evaluations as long ago as 1993? And then there were certainly some in 2000 that were utilized. And I guess behind this question is, how much of that was relied upon for the 2012 diagnosis?
Well, in the 2012 case, there were two experts from the original trial who had done some things who testified. But the main part of the state's testimony was two experts who had evaluated Ramage as part of the 2012 proceedings, Dr. Kors and Dr. Adam. And they looked at, of course, Ramage's entire case file. Obviously, in evaluating something like this, you look at everything that's there. But their evaluations were current. They weren't based on what was there.
So there wasn't just reliance on the earlier evaluations, there were current evaluations.
They were current evaluations. They, at least, I think both of them interviewed Ramage and based their assessments on their interviews, their review of his records, including information that had postdated the 2000 commitment, including his probation, parole violation.
So the review of the prior evaluations was just kind of background, or were those the foundation for making the 2012?
I don't think they were the foundation. I mean, they were certainly something the experts looked at and took into account, and they were relevant, obviously, to the extent that these are lifelong diagnoses.
But the means by which we diagnose current medical condition certainly evolve, and that's my question: is
Sure.
just to solely rely on something from 1990 or 2000 in 2012 would not be the way you would diagnose someone. But you would use that information, but you wouldn't solely rely on it.
That's correct, and that's what the state's experts here did, is they based their evaluations on their current review of both the records and their interviews with Ramage and the entire case file. So because these are separate proceedings, the law of the case doctrine doesn't apply. But even if they were the same proceeding, the law of the case doctrine still wouldn't apply because there was no prior determination in 2000 that this information, as Ramage claimed, should have been excluded. And therefore, that's just not law of the case. The law of the case doctrine has nothing to do with what evidence can be admitted, except unless there was a prior determination on that issue. Finally, in his petition for review, Ramage mentioned a couple evidentiary issues, relevance and hearsay. The Court of Appeals found that those likely weren't adequately briefed, and Ramage didn't file a supplemental brief in this court further briefing those issues. But even so, the Court of Appeals correctly held that there was no merit to those issues. I don't think much more needs to be said on those unless you have questions, other than I would just point out that the Court of Appeals did make a minor mistake in terms of what opinion can be admitted outside of the SVP context. It cited a prior case interpreting KSA 60-456, but by the time of Ramage's trial here in 2014, that statute had been amended along with KSA 60-458 to basically adopt the Federal Rule of Evidence 703 regarding expert testimony and reliance on hearsay. That, of course, doesn't affect the Court of Appeals' correct analysis here because that's outside of the SVP context.
What, in light of this court's raising questions in N. Ray Sporn about the ability of the state to file multiple actions, what's your authority for saying this is a separate suit?
Well, first of all, Sporn was a res judicata question. Here, although Ramage raised a res judicata claim in the district court, he didn't raise that on an appeal. It's not in his petition for review. He solely raised the law of the case doctrine. But to the extent, the state's briefing in the district court on the res judicata issue raised several points. The first, as was discussed earlier, the dismissal in the 2000 case was jurisdictional, so it wasn't on the merits, and therefore the argument was res judicata doesn't apply. And the second argument was, as Sporn indicated, if the person's mental condition had changed and there's new evidence on that, there could be a new proceeding. And here there's the fact that in 2000, after he'd been released once the SVP proceeding had been dismissed, he violated the terms of his parole by having contact with an underage child, which he was prohibited from doing so, and also hadn't successfully completed his sex offender treatment at that point. So there was new evidence, even if the first case was an adjudication on the merits. So those are but again, that's res judicata, which wasn't raised on appeal, wasn't in petition for review, and isn't before this court. Was there any further questions?
Any more questions? Thank
The
you,
state
counsel.
would just urge you to affirm the decision of the Court of Appeals. Thank you.
Well, to briefly reply to the state, is this the same case? Yes, it is. It is the same case. If you look at the petitions that were filed in 2000 and 2012, they're almost identical. And in fact, at the trial, they had two witnesses who who were prepared to testify at the 2000 trial.
I understood you to argue earlier that the first case was a dismissal on the merits.
Yeah, it is. But if you accept the state's argument, then this is they're trying to. The state gets one shot at this. Okay, they get one shot at filing a sexual predator petition. The concern in Sporn, as was raised, is that we're open. If we allow this, then we're opening ourselves to multiple predator petitions until the state finally gets somebody committed. That's, I think, a defect of the law, because the law says that you have to find that somebody currently meets the definition of a sexual predator. Well, their condition may have changed between 2000 and 2012. The other thing is that the new petition was, of course, based upon the initial conviction, but they're trying to bootstrap it by saying, well, he violated his parole. That's not a charge or conviction. Okay, that's a parole violation. The standard of evidence is not the same in a parole violation as it is to file a charge or to convict on a charge. But they used the file they used, the witnesses they used were the same, and as Justice Miles pointed out, there was a heavy reliance on the same witnesses in the file and the evidence that had been used. Was there a prior decision? Well, yeah, I'm arguing that there was under the Moore case, and there's another case that is Netwig. It's a Netwig case. It's a federal case, and that also seems to support the fact that a dismissal based upon a time limit or statute of limitations is a dismissal on the merits. So then, you would have the issue preclusion doctrines would apply. So we're asking that the court find that the evidence used in the first proceeding in 2000 is not admissible. The state can still proceed on this, but they're going to have to use evidence that was, gathered after the first dismissal, and they're going to have to use more current evaluations to get at his current mental state. All this stuff from 20 years ago might be fine, but it doesn't really establish conclusively what his condition is at the time, now, currently. So if there are no further questions, we would simply ask that this court reverse the decision of the trial court and the Court of Appeals.
Do you have any more questions? Thank you, counsel.
Thank you, Judge.
Thank you both for your arguments this morning. Clerk will take this matter under advisement.